Welcome to Lecture for Abnormal Psychology. I'll be talking this time about legal and ethical issues. Overview, we'll talk about civil commitment, talk about criminal commitment and the use of the insanity defense, patients' rights, some stuff about evidence-based practice and clinical treatment, and then a smattering of other legal and ethical issues. Okay, civil commitment. What is it? It's a legal proceeding for hospitalizing a person with mental illness. When we say mental illness, notice we don't say mental disorder. Mental illness is a legal term, which we'll talk more about in a bit. It's typically done justified under one of the two following reasons. One, the parens patriae rationale, which is acting in the place of the parent, right? So you have parent country. So the government of the country is acting as the parent. So this is whenever you're hospitalizing someone to protect them. You're worried they're going to hurt themselves or not be able to take care of themselves. So the government, society says, we'll be your parent, we'll take care of you, we'll shelter you, even though you maybe are an adult. Or it's done using justification of police power. So this isn't so much to protect the individual from something happening to them. This is to protect the rest of society from that individual, right? So the criteria generally for civil commitment, again, have to have mental illness, which is a legal concept, and it varies across states, the precise definition. In Texas, it's an illness, condition, or disease that it's thought to impair thought, perception of reality, emotional process, or judgment, or impairs behavior. So you have to have that. You have to have mental illness. And again, being diagnosed with something in the DSM, mental disorder, isn't sufficient to meet the criteria of mental illness. It certainly helps a court deciding if someone's mentally ill if they have a DSM diagnosis, but it's not neither necessary nor sufficient. So you have to have mental illness, and then one of the following: either dangerous to yourself or other people, or unable to take care of yourself. And we'll see a lot of the law in certain steps leans heavily on the first one, that kind of dangerousness, and then a little bit more about the unable to take. Two types of commitment: voluntary and involuntary. For voluntary commitment, you have to be at least 16. So you don't have to be 18, you can be 16, 17 years old to commit yourself to a mental institution, even if your parents don't think you should be committed. If you do, and you get a doctor to agree, you can be committed. Or the parent of someone who's under 18. So a 16-year-old can commit themselves without their parent consent, and the parent can commit them without their consent. But an 18-year-old, well, for voluntary commitment, it has to be their own deal. Parents can't take their college freshmen and have them committed. And so you also have to get a doctor's order. So you go to the institution and you say, I want to be committed, and there has to be some doctor willing to sign off that yes, you should be. It's not just well, I'd like to take a insurance-paid vacation for a while. There actually have to be some need for intervention that some doctor gets on board with. Now, if you voluntarily commit, how do you get out? In Texas, not that difficult. You submit a written request, and they have to release you within 4 hours of that written request. Pretty quick. Unless, when you're in there, the doctors then say, we think maybe you should be here. And they then have 24 hours within which to conduct a new evaluation and determine if the process of involuntary committal should be enacted. But you also can't be switched to involuntary if you're cooperating with reasonable treatment. So if you commit yourself, as long as you're kind of doing most of what the doctors say, and if they say, we want this new experimental treatment, you can refuse that. You still retain some rights. They can't say, well, you're refusing treatment, now you're going to be involuntarily committed. No, it doesn't work that way. You stay voluntarily as long as you're cooperating with reasonable expectations. Now, if you commit yourself voluntarily and then you refuse to take any medications, for example, well, that might be then grounds for them to switch to an involuntary committal, which is a whole separate process for. That process in Texas can occur in a couple ways. Sometimes it starts with an emergency detention. Not always, but frequently. So this is where you're taken into custody because you're a danger to yourself or others typically. So who can file the application for emergency detention? Any adult in the state of Texas can file a written application for the emergency detention of another person. So if you think somebody needs to be taken in to be evaluated for treatment, you can submit this form, take it to a judge, and if they agree with you, they'll issue an order. For what reason? So the reason for the emergency detention is you have reason to believe the person has a mental illness, again that legal definition, and they're a danger to themselves or others. So for emergency detention, it's not that they can't take care of themselves. So you see somebody that maybe is homeless and on the streets, they appear to maybe have schizophrenia, and so you think, oh well, they seem to have mental illness, and because of that they're not able to take care of themselves. That wouldn't be enough for an emergency detention because it's not emergent. Emergent is more about that danger to self or others. So who can do the detaining? Can say if somebody presents to the ER and they're having a psychotic break or they're high on some substance, can the doctors detain them? If they say, I want to get out of here, no, they can't, unless the police officer is there, which is why you often have officers of the law in the ER, because you need an officer to do the detaining. They're the only ones that have that power, and they can only do it, again, if they think the person has mental illness and is a danger to themselves or someone else. And again, they don't have to be necessarily trained to make those determinations. If a credible person tells them this person has mental illness and they're a danger to themselves, so if a doctor, psychologist, counselor, clinical social worker tells them that, and that's a credible person, the officer then can do that emergency detention based on their report. But typically they need to see the person, and they will interview themselves, make a determination. How long can you detain someone for in this kind of emergency protocol? About 48 hours. So that initial detention can be up to 48 hours, but that person must be examined by a physician within 12 hours of either apprehension if they're out in public or transportation. Let's say they're at a clinic and now they've got to be transported to a hospital for the evaluation. Within 12 hours of that transportation or apprehension, they've got to be seen by a physician to be evaluated. At that point, when they're evaluated, they're either admitted by the medical personnel, which the doctor then signs orders for their admission, or they're released back to on their own recognizance, right? So if a doctor signs an order, does that mean they stay in the hospital forever? No. They can be admitted to the hospital, but for them to stay there if they want to leave requires the next step, an order of protective custody. So this is something that's issued by a judge or a magistrate, if the judge gives that power to the magistrate. And again, the timeline is a little different here. So a protective order goes into effect for 72 hours instead of 48, so it extends it a little longer. And the requirements, again, are the same, though, where it has been established, issued by a judge, is to get an order for mental health services. So this is where you can say, okay, now you need to be admitted to inpatient, or you need to get outpatient for an extended period of time, and you have to do it. We're going to mandate either you stay in the facility or you have to come back to the facility repeatedly. So within 72 hours of that protective custody order, right? So again, that order of protective custody is good for 72 hours, and within that time, there has to be a probable cause hearing. Now, the probable cause hearing is longer until you have the final hearing. Now, the final hearing is more formal. Can be in front of a jury if requested, but it's often not. Often that's waived. And at this point, This is where the testimony of non-physician mental health providers is often considered. So counselors, therapists, psychologists that are working with the individual may then testify about their dangerousness, their stability, their need for treatment or lack thereof. So up until here, it's just physicians saying, yep, you've got to attain them. Now finally non-physicians get a chance to have some voice and some role in the process. Not really much one until then. So then at that final hearing, again, it could be determined, nope, they don't disagree with that first judge. Let them go. They're fine, or they're fine now. They maybe had a brief psychotic disorder, but they're perfectly fine. Let them go. Or they are going to mandate treatment. So if they mandate, how long can that order be good for? It's weird how it's worded in the law in Texas. The standard is 45 days, but the judge can specify up to 90 days. But looking at kind of what typically happens, these orders are often for about 30 days, which is not surprising if you look at how long insurance companies often pay for inpatient care. They often cap it at 30 days a visit, which may be why you're not going to order them for more than that, because nobody's going to pay for it, and then the county's on the hook for that cost. So typically about a month, but up to 3 months, they say, yep, they need to be there at least that long, unless they're discharged, right? So in that time, so the judge says, yep, 45 days, doesn't mean they have to stay there 45 days. If during that time the physicians who are signing the orders evaluate them and say, nope, they're fully recovered, they're able to go, they're not a danger to themselves or others, they can go home, and they can go home early, right? But the person can't just get out because they say they're fine until 90 days. At 90 days, again, you have to have something else happen, another hearing or discharged. Now, if somebody has gone through this, right, so they were ordered, let's say 90 days, and they're an inpatient, and they've been there for a while, and if they've been there for 60 consecutive days, and then they come back to the courts and the doctor says, this person, they're not going to get better anytime soon, they can file for an extended treatment, and that can get approved for up to 12 months. Right? So if you've been there for 2 months and you don't seem to be getting better, the doctors don't think you're getting better, now they can present that case to the judge and say, yep, we don't want to be coming back every 3 months to do this hearing. That's going to be a while. And the judge can go up to a full year. And again, in that year, if it's determined the person has recovered, then they could be discharged. But they can't get out on their own until that 12 months comes up. Either they're discharged or you have another hearing and then you renew it again. So the requirements or reasons, here's where it changes. And again, this can be for inpatient. That's typically what we talk about. We talk about commitment, but you can also have court-ordered outpatient. The judge thinks, based on testimony, okay, this person needs treatment. They don't want it, but they need to get it. But they have a family or friends that can kind of take care of their needs and make sure they come to treatment. They can also be ordered for outpatient treatment with the same kind of timelines applying. Okay, there have been lots of policy changes over time regarding civil commitment in the U.S. Of course, some early court decisions, which also played a role. O'Connor versus Donaldson. This is where a family, they had a son who had schizophrenia, and they had him committed. Then we had Addington versus Texas in '79. Became increasingly difficult to commit people that didn't want to be receiving psychiatric or psychological services, primarily inpatient is what I'm talking about here. So the perceived and actual results of changes. One thing we talk a lot about is the criminalization of the mentally ill. Folks that now aren't being committed because we made it harder to commit people, also not getting any treatment, started to get in trouble with the law, right? And so you have this movement where it's harder to put people in psychiatric institutions, but they're still kind of getting in trouble because of aberrant, odd behavior, trespassing, yelling at strangers, doing things that are going to get you noticed by the police. And so they're increasingly being put into jails rather than treatment facilities. And again, jail's not the best place to get treatment, right? Because they have a lot of other things they have to worry about in terms of keeping people safe from each other and keeping society safe from people that are put in jail. On top of that, you had, as we've talked before, about this deinstitutionalization movement, because you had the asylum psychiatric hospitals in America, became overcrowded, quality of care dropped significantly, and they were just housing people, not treating people. They were bad. And so there was this big movement in the 60s to deinstitutionalize, where we have these community mental health centers to take care of people instead. And of course, that didn't work out so great. Swing back the other way with some court cases to make it easier to commit someone. So we made it, it was too easy, and then so we made it harder, and now it's more recently swung back to become a bit easier to commit someone, because, well, instead of committing them, now they're ending up either homeless or in jail, so we need to go back the other way. So what's next in terms of these changes? I don't know. In terms of criminal commitment, so again, the civil commitment can't be used if you're charged with an act of violence of bodily harm. So for those type of things, we have more the criminal commitment if there's mental illness. So this is whenever someone's committed a crime, but they're deemed not competent to stand trial due to mental illness. So if there's a mental illness, they don't seem to be in their right mind, so they can't participate fully in their defense. So it would be unconstitutional to try them for a crime until they can participate. And so often what you have is this aim to restore them to competency, right? So they get criminally committed, where now they're going to be made to get treatment, inpatient treatment, until such time that they are returned to competency, until they become rational and can participate fully in their defense, and then they go to trial and they go through the criminal process. And typically you get 60 to 120 days, depending if you have the type of crime that you've been charged with. During that time, when they're trying to restore you to competency, if part of that is going to involve medications, where they're going to be making the patient take meds that they don't want to take, it takes 2 doctors to sign off on that, saying that it's medically needed and appropriate. 1 doctor at the facility that the person is at, and then a second doctor who is not at that facility and in no way affiliated with this person. To again, try to have some protections in place to not just be drugging people against their will, willy-nilly. If they can't get that restoration to competency, right? So if in 2 months, 4 months, they can't get to a place like a stand trial, then you go to the extended commitment, where every 12 months they're being reviewed to say, okay, are they competent now? Are they competent now? But another kind of avenue, it's written into the law, it's interesting, is the court can also decide to drop all the criminal charges and refer the person for civil commitment. So if they believe, oh, this person's mentally ill, we're pretty confident we can commit them even against their will civilly, and they're going to be treated, then they can, because you can't use civil commitment while someone's being charged, they can drop the charges and then refer them for civil commitment. So if you are committed, you're charged something, and then you're going to the criminal commitment process, you can't be held in an inpatient facility against your will under criminal commitment longer than you would have served if you had been found guilty of the crime, right? So if it's a 5-year prison sentence, you can't do 6 years in a psych hospital, right? You can do 5 years in a psych hospital, and then after you reach the max of where that sentence is, okay, you can stay in the psych hospital, but you have to then go back through the civil commitment process. You've served your time, paid the society back your debt for justice, rehabilitation, whatever. But if you're not well, they don't have to just let you go. If they think you're not really a danger to yourself or others, or again there's that danger of deterioration, then you can go through the civil commitment process and then be kept for as long as it takes. The insanity defense, something that kind of what the public perceives when it actually goes on, big gap, right? So it's not attempted nearly as often as the public thinks, and when it is attempted, it's not successful nearly as often as the public thinks. It's a small percentage of cases when people plead, not guilty by reason of insanity, and it doesn't typically work, right? Less than half the time. One move that's concerning to some mental health professionals is that in some states they've moved to this guilty but mentally ill, where they've gotten rid of the not guilty by reason of insanity. They think, oh, this is loophole. People are getting off scot-free, which again, they're typically not getting off. They're typically going to a lockdown psychiatric facility, and again, for often ultimately staying there longer than their sentence, because after the criminal commitment expires, they're civilly committed and they end up staying denied of the freedom of movement for longer than they would have if they hadn't pled that way. But anyway, a lot of people think, oh, it's this loophole, and so they said, well, we got to make sure we lock them up anyway. So they'll say, oh, you're guilty, but by the way, that you're mentally ill, we'll provide you what treatment we can while you're in prison, which usually isn't. Okay, patients' rights. Patients have a right to treatment, and this isn't like the right to health care. Sort of touches on it, but this is right to treatment if you've been involuntarily committed, civilly or criminally. So if they lock you up because, oh, you're mentally ill, you've got to get treatment, well, then you actually have to get treatment, right? And this came up with the Wyatt versus Stickney case in Alabama, where you had this grossly underfunded mental health program. You had, I think one case, it was like 5,000 patients and one psychologist responsible for those 5,000 inpatient psychiatric patients. Just ridiculous. People weren't getting treated. And so they sued, and the providers were suing, saying, hey, patients can't be taken care of at this level of funding. And after about 3 decades that they won, so the laws have changed. And the laws that changed, why this matters is it set kind of minimum standards for treatment facilities, both for psychiatric facilities as well as places that for individuals with that are institutionalized for intellectual disabilities. And things even as kind of rudimentary as, how many toilets do you have to have? What's the ratio of people in the facility to toilets and beds? Those type of things, because they weren't there before, which led to overcrowding, unsanitary conditions, also a number of providers and all these things. So minimum standards of treatment have been established as a result of this. And also this push for the least restrictive alternative, right? So this is typically, okay, well, if this person can only be successful if living with roommates and become a group situation, then that's what you got to do. If they can live independently alone, well, independently is less restrictive, so then they should live that way, right? Do they have to have that door locked, or can they not have that door locked? Are they allowed to leave the facility or the campus, or are they not? And again, the least restriction you can put on them is what you should put on them, is what's been kind of put into the law. In terms of patients having the right to refuse treatment to some degree. It's kind of with Riggins versus Nevada, where he wanted to, he was forced to take medication to treat his psychosis, and was able to stand trial, was competent, and said, okay, yeah, but I'm competent, I'm saying yes, clearly, but when I'm during the trial, I want to be taken off my meds so the jury can see how unhealthy, how insane I look without my meds, which is how I was whenever they say I committed this crime. And ultimately they said no, and they made him take his meds, and he was found guilty. But because he then sued, and because of that, they said, okay, you've got to again reaffirm this least restrictive alternative, and then also said if you're going to mandate treatment, it must be medically appropriate. And in his case, he didn't bring up the whole thing of they need to be able to see me unmedicated. That argument didn't come before the court. But what came before the court was that the state didn't establish that the medication they made him take was necessary and appropriate, and because they didn't establish that, he won on that. So you can force people to get treatment, but you have to establish it's medically appropriate. That's why, again, in Texas, you have to have those 2 doctors signing off on forced medication. Another issue in counseling, therapy, psychotherapy, confidentiality and privileged communication. Confidentiality, the idea that what you tell a therapist, a counselor, they don't tell anybody else. That's an ethical obligation on the part of the counselor. They have an obligation for confidentiality that they should not discuss your case outside of appropriate channels, which would be clinical supervision, consultation, where they need help with the case. And when you do that, you use as little identifying information as possible, but they don't tell their husbands, wives, partners, friends, hey, I saw this person today, you wouldn't believe what they said, right? You don't do that because confidentiality is super important. It's super important because if clients don't have faith that things will be confidential, they're not going to share their intimate thoughts and feelings. If they don't share their intimate thoughts and feelings, counseling is often pointless. So that's an ethical obligation on the part of the counselor. Related to that, but a separate concept, is this idea of privileged communication. That has to do with the patient, the client's right, a legal right to privilege, that their privacy will be respected, and that nobody can know what they tell their counselor outside, again, of appropriate channels, which include consultation, supervision, and also reporting to a third-party payer, things like diagnosis, progress, if your insurance company is paying for it. So that's there's the ethical part, which is confidentiality, and the legal part, which is privilege. And the client is the holder of the privilege, and they can give up their privilege, right? They can sign a piece of paper saying, "Oh no, you can tell this doctor, tell this person, whoever, this thing because I want you to, because it's their right, right?" If they say, "I want you to tell this other provider," you can't say, "Well, no, it's confidential. I can't tell them." No, it's their information. They have the right for that to be shared. And again, there are exceptions to that privilege. If a client indicates that anything about someone who's a minor, older adult, or disabled person who's a victim of abuse or at risk of abuse, then you can break confidentiality, violate privilege, and report to the appropriate authorities. And you can't tell your friends about it, but you tell, Department of Protective Family Services, Adult Protective Services, the police, whoever is the appropriate party. Or again, if we go back to what we talked about before with committal, if the person reveals that they are a danger to themselves or someone else, you can break confidentiality. You can violate their privilege to, again, inform the appropriate person. And we'll circle back to that, who the appropriate person is when it comes to dangerousness here in a bit. Also, related to patients' rights, individuals' rights, when it comes to being a research participant. So if they're a patient in a clinical study, they've got some rights. The right to informed consent. So they have the right, whenever they're going to participate in research, they should consent to do it, and their consent should be based on being informed about the risks involved and the benefits involved, and also any remuneration, any benefits they may receive, and any costs to them. They also have a right to privacy, right? And that's part of informed consent, is to let them know the level of privacy, like, okay, everything you say will be anonymous, or everything you say will be confidential, and the information is going to be locked behind 2 locks and maintained for 3 years. Here are the people who have access to it. All that sort of stuff needs to be told to them, and they need to be guaranteed of some level of privacy and informed about that. Protected from harm. So you want to intentionally cause harm to research participants, which again is not something that researchers always did. Sometimes they did subject people to harm or let bad things happen to them knowingly without telling them. Really bad. And then participants also have a right to quit at any time in the study. Yeah, you want to drop out? Okay, you're out. Just let us know. Okay, evidence-based practices. So there are some laws in place and certainly ethics surrounding what type of treatment you can or should provide, right? And there's certain things that have been outlawed. You can't do this. That's quackery. If you do this, that's malpractice, and you'll be sued, right? So why does the government care about how disorders are treated? Well, one reason is the government cares about its people, maybe, and wants them to get the best treatment. That would be nice. But a lot of it, honestly, has to do with the government is often footing the bill for treatment. And if the government's going to be footing the bill, right, via government subsidies for healthcare or government healthcare programs, they don't want to be paying for things that don't work. So there's a big push for, okay, if you're going to be providing treatment and we're going to be paying for it, you need to show us that it works, that it's effective. So the two dimensions we look at for this kind of idea of evidence-based practices, do they work, are clinical efficacy, which is, does it work in studies? When you do your clinical trials where you've got carefully selected samples from populations and you're monitoring them, you're assessing all kinds of things, you're eliminating these external events that may influence different things, you're exerting all kinds of experimental controls to make sure, okay, if this group and this group differ, I can be confident that difference is due to treatment and not due to, well, some people did this, some people did this. No, I watched everything they did, and the only thing they did different was this treatment, right? So when doing that under these kind of empirical conditions, did the study work, right? That's an important question. If it didn't work in those settings, well, it's not going to work elsewhere. Problem is, sometimes it works in that setting, sometimes artificial lab-like setting with lots of control, selecting only, especially in clinical research. Okay, we're looking at treating depression, but we want to, nobody in the study can have a comorbid substance disorder, eating disorder, or anxiety disorder, because we really want to focus on depression. You go, okay, cool, that's reasonable. Yeah, but once you get to the real world, how many folks that you're going to be coming in for treatment for depression are like that don't have a comorbid disorder? Well, not that many. Like, a lot of people will have something else in. So what if it doesn't work if you're comorbid with another disorder? And that's where the other dimension, the other axis comes in, clinical utility. Does it work in the real world? Which, again, you want to establish the efficacy first, right? In a controlled setting, does it work? Okay, now, when we get beyond this lab with different providers, so maybe they were psychologists or psychiatrists that did it here, or clinical social workers. Okay, now if we have somebody else do it in the real world, counselors, therapists, whoever, and for maybe a different amount of time. This was a 3-month thing. Okay, can we do it in 2 months? Or we're going to stretch out to 5 months. Will it still work with non-standardized conditions, right? And both things matter. And you look at both when looking at evidence-based practice. Problem is, it's not like, okay, well, here's the cutoff. If you're this high on this dimension, this high on this dimension, we're good. All you can do is consider these dimensions to make arguments for what has the best evidence, right? That's why we moved away from, for a while, they talked about empirically validated treatments, which suggested, okay, science has said, yes, this works. We got away from validated to more evidence-based and evidence-supported, saying there are some data for this, but we can never say, yep, it works, because that's just not how behavioral science functions. All we can say is more or less support. So which treatments have the most support? Now, related to that is an interesting question. What outcome or outcomes should be measured? Because some things are easier to measure than others. And some treatment modalities are easier to study and document success than others. So think back to what we've talked about, all these different disorders and abnormal behavior. Should the outcome be you no longer meet criteria for a diagnosis? Okay, there's some diagnoses that may make sense. There's some we think, well, this is more kind of characterological, like generalized anxiety disorder. You don't meet criteria at all, or you don't meet the distress criteria, doesn't bother you as much, or is that you're no longer worrying? What's the thing we're looking for? For somebody getting better, say this treatment is working, what matters? And the research often falls in one of two camps. One camp being what matters is symptoms. So looking at some criteria, symptom criteria in the DSM, saying, do we see a reduction in symptoms? Another camp says, Well, yeah, symptoms are important, but even more important, kind of think about that clinical utility dimension is, are they going to work? Are they having relationship problems? Um, are they paying their bills? Are things okay? So looking at functioning. So regardless of how many, nightmares you're having, how much you're binging, purging, how are you functioning in the world? Then maybe that should be the outcome we look at to see if a treatment works, right? Because if we reduce your symptoms, kind of like with ADHD, you're no longer inattentive or hyperactive, but you're still failing and going to the principal's office all the time. Well, did the treatment really work? Maybe. And again, no easy answer there, but an important thing to consider when looking at research about efficacy and effectiveness is, well, what's the goal? What should the outcome be to say that this is an evidence-based practice and something that we want to put our money behind and support? Okay. A last little round of some other legal and ethical issues that don't fit neatly into the other topics. The death penalty. Death penalty, why is that there? Well, the death penalty is here because often there's a mental health professional, a psychiatrist, psychologist involved in testifying when people are up for the death penalty, whether or not they have a intellectual disability, right? Because in some states that's part of a determination for if it's an unjust, unconstitutional punishment, because it seems some states believe it's unjust to execute someone who has a sub-average IQ because they have diminished capacity to know what they did was wrong. Right? So they're competent to stand trial, they're found guilty, found responsible, but should they die for it? Right? And in some states it matters, some states don't seem to care. But whenever that determination comes up, there's usually some mental health professional involved in that determination of if this that's going to influence whether or not somebody lives or dies, which is both a legal and ethical issue. Duty to warn. So this is coming back to that confidentiality thing we talked about before. If a client indicates that they're going to hurt someone, they're going to shoot up a school, they're going to shoot some person, stab somebody, blow something up, do you have a duty to warn? So the case, the landmark case everybody talks about in California, the Tarasov case, sad story. College student who had, there was another college student who was obsessed with this woman and was in treatment with providers and told them, oh yeah, I'm gonna kill her. And the providers called the campus police, said, hey, this person said they're gonna kill this person. We think you ought to know that. And the police then went and talked to the person, and they said, hey, they said you said this, and he said, oh yeah, no, I was just upset. No, I'm not gonna do that, I promise. I promise I'll stay away from her. And they did for a couple of weeks. Right? So the therapist, met some level of obligation of telling the officers. The officers did their obligation of interviewing, and they determined the person wasn't dangerous. And again, our ability to determine if someone's dangerous or not, pretty good short term. And they were right, short term. Bad news is longer term, a couple of weeks later, that student stabbed and shot Tarasov to death. So the family sued and said, you have a duty to warn. And, the provider said, well, we told the police. We did what we thought we should do. He said, no, you need to warn the potential victim. That's what the duty is. Now, that case has kind of gone back and forth. And in California, that's generally the understanding is that, yeah, you do have a duty to warn the victim. Oops. However, in Texas, it's been a while now, when Abbott was still the Attorney General, issued an opinion saying that Tarasov does not apply in Texas. And again, that's just an opinion. That's kind of what everybody's going off right now. There hasn't yet been a case law precedent to really test this out in the courts in Texas yet. But the way everybody's been going for the past 10, 15 years is that Tarasov does not apply in Texas. That if someone says they're going to hurt somebody, you do have a duty to notify the authorities. So do what they did in California. You break confidentiality, you violate privilege, and you tell the police this person is going to kill this person, and here's their car, here's their address, here's the phone number. I strongly suggest you go get them, right? And then they go do the emergency detention, 48 hours. They'll bring them in, and then possibly criminally commit or civilly commit, depending on if they get charged with anything. Now, why do you think, if any of you have been in Texas for a while, why in the state of Texas might it be a bad idea for a counselor to warn a victim, hey, I just got out of session with this person, and they are coming to shoot you, and it's my duty to warn you. Why might that be a bad idea? Okay, we'll play out the scenario. The client is upset, and they say they're going to kill boyfriend, girlfriend. They drive off to their residence, and on the way, they settle down. They go, you know what, I was out of my mind. What was I thinking? I love them. I would never hurt them. They go to the store, pick up flowers. They, in the meantime, you've called the person, said, hey, they're on their way to kill you. In this being Texas, fairly decent odds that person is armed, has access to a firearm. So now the client has gone to get flowers, goes and knocks on the door. Person opens the door and shoots the client holding the flowers. And now you're an accessory to murder. They've committed murder because the person just has flowers. Didn't really have reason to believe their life was in danger other than what you told them, which may not have been accurate. So that's one supposition for why this may not be a good idea to warn the victim in Texas. And again, let law enforcement handle it. Okay, so duty to warn applies seemingly only in California. Other states haven't extended it. Texas in particular has explicitly said in one opinion of the Attorney General doesn't apply, and that's one argument for maybe why that might be a good idea. But you still do warn the authorities, and they can do that emergency detention. Mental health care providers working with people with abnormal behavior also sometimes are called on to be expert witnesses involved in the judicial system. And sometimes they're called on to make some determination regarding predicting dangerousness. And as I said, with a good amount of data, interview, clinical assessment, inventories, we're pretty good at assessing how dangerous somebody is for anywhere between 2 days and 3 weeks. Outside of that, not too good. Right? Can't say a month from now they're going to find a month from now they'll be dangerous. We don't know. People change, right? In the course, depending on what kind of disorder we're talking about, it can wax and wane. Symptoms can appear to be getting better, and then boom, they come back hard given certain shifts and stressors in the environment, things going on neurologically. It's just not that predictable. We're an unpredictable species. So short term, pretty good at predicting dangerousness. Long term, not a great track record. Another role sometimes people are called on regarding abnormal behavior is to testify in the detection of malingering. Right? We talked before when we talked about disorders related to medical symptoms. Anytime somebody's faking an illness, or particularly a mental illness, psychologists, counselor, therapists might be called to testify, and we're pretty good at detecting malingering. There's some sophisticated assessment techniques, basically where you're evaluating the presence of symptoms that to somebody who hasn't taken lots of abnormal psych would go, oh yeah, if I were to fake having schizophrenia, I'd probably say this. That sounds like a symptom I would say, but really they're the symptoms that don't exist in that disorder, or they're incredibly rare. And if somebody's presenting with a lot of rare symptoms, then that's a pretty good indicator of potential malingering. So someone's put in that role of looking for that. But important to note that mental health care professionals have to be cognizant not to serve dual roles. Right? So if you're going to be an expert witness, you can't be an expert witness in a case involving your own client. Now you can be a fact witness. On this date did your client say this? According to my notes, yes, they did. That's fine. But you can't be an expert witness because that's a dual role. You can't both be their counselor and an expert on some subject for that client. That would be an ethical violation. Okay, that's enough. Okay, wrapping up. take-home stuff. It's a tricky balance with the stuff in terms of individuals with abnormal behavior and mental disorders, mental illness, finding this balance between safety, keeping them safe for themselves, keeping the rest of society safe from them, and also maintaining a respect for autonomy, which is huge, particularly in the U.S. Kind of culturally, we're really big on individuals' rights, and you should be able to determine where you go, when you go, and what you do. And just because you may be having certain struggles doesn't mean you give up those rights up to a point, right? But there is a point, and there's a process to determine that point where your rights get reduced. But that's something I think that we'll continue to struggle with as a society, and in our legal system is finding that balance to, okay, let's keep ourselves as safe as possible without, giving up all rights and saying, okay, making it super easy to go back to where it was, late 1800s, early 1900s, where you could easily deprive people of their rights, for a variety of reasons, just by playing some sort of mental illness card. Underfunding mental health treatment undoubtedly causes a burden on the judicial and criminal justice systems. If people aren't able to get treatment, again, even if they're not going into the prison system, criminal justice, getting prosecuted and having to be sorted through there, still going through a judicial system with civil commitment, criminal commitment, that takes up time, energy, resources. Whereas if you had increased access to outpatient funding, where people are getting early identification, we're getting more preventative efforts out there to reduce the likelihood of the onset of symptoms that cause impairments in individuals, well, then you wouldn't have all these cases taking up slots on dockets and all these people in jails and prisons. That would be nice, I would say. Last thing to keep in mind is that individuals exhibiting abnormal behavior that suffer from mental disorders and, in a legal term, mental illness, are to some degree a vulnerable population. And I mean that both in terms of when you're conducting research, they're a vulnerable population because they may have diminished capacity to provide informed consent. So if you want to study, the effects of this new treatment on bipolar disorder, okay, to what degree can these individuals who are suffering from that, can they rationally give consent, particularly if they're in a mood episode, a manic episode, or a major depressive episode? That's an ethical, tricky question. Okay, because you say, okay, well, then if we won't do the research. Well, what if the research could lead to a breakthrough in treatment, which would then help them? So there's a possible benefit, but we don't want to take advantage. It's tricky. They're vulnerable. And then also in terms of the legal system, they are a vulnerable population. Difficult to participate fully, again, in your defense, difficult to access the resources you need to navigate a fairly complex legal judicial system we have here in the U.S. If you have some impairments that affect your ability to think clearly and make rational judgments. So something to think about. There are lots of opportunities to advocate for these populations and to work in a position where you can lend a hand and be an advocate. That's all for now. Take care.